In this video, we would like to discuss question number 9, that is relating to explain the very concept of joint Hindu family and Coparcenary. Is there any change into the concepts after enactment of the Hindu Succession Amendment Act 2005? So, regarding the very concept of joint Hindu family, it is a special feature and unique in Hindu society as it was explained under the Mitakhar school in Hindu law, and exactly the very common features which identified a joint Hindu family as they are joint in food, worship, and estate, and there is the very concept of separation is absent, and they possess the estate or property or the joint property in common. So, even if that any member holding property separately would not be considered as joint property, and it is governed under the very senior most male member of that joint family, and who is considered as Karta, and usually the father of that joint family is considered as the senior most male member or Karta, and there is common enjoyment of joint family property, and that is otherwise called Hindu Coparcenary, which acquire interest by birth. So the sons, grandsons, and great grandsons are considered as the very members of that joint family, which is also considered as Hindu Coparcenary, and all the members are common male ancestors with his lineal descendants in male line are the members of the Hindu joint family or joint Hindu family, and this consideration of joint Hindu family as under Hindu Coparcenary is continuing for 3 generations, and every member have the right of Coparcenary regarding the Coparcenary property of that Hindu Coparcenary to demand partition, and they have control over the entire property. So, no member cannot transfer. Here it means the exactly the Coparcenary or the senior most male member of that Coparcenary could not transfer without the consent of other members of that joint family or Coparceners to sell or to mortgage or to any type of transfer. Regarding that, the consent of all other members of the Coparcenary is required, and the very ownership of the property that devolved or devolution of that right to property is based on survivorship, and exactly the very coparcenary regarding joint Hindu family. Here coparcenary means the, the very ownership, and that ownership of that coparcenary is otherwise considered as unity of ownership, and that unity of ownership is also combined with community of interest. That means the entire member of the coparcenary of the joint Hindu family have ownership right over the entire property of the coparcenary, as it involves the interest of every member of that coparcenary, so it is called community of interest. And another thing is that the very shares in a coparcenary is indeterminable as regarding, because due to the death or by birth in the joint Hindu family, it would be difficult to exactly determine the shares of each members of that coparcenary, as if one member of that coparcenary or the joint Hindu family died, in case that the very share of other members would definitely increase, and if any new member born into the joint Hindu family, then regarding the right to coparcenary would definitely and proportionately will decrease, as due to birth of a new member into the joint Hindu family regarding the coparcenary right. So, another new feature that is common in all coparcenary in joint Hindu family, there is the very exclusion of all the female members of that coparcenary regarding their right to ownership of the coparcenary property, in which the female members are denied the very right to property in the coparcenary. So also right by birth, it exactly another feature. So any member or any person born in a coparcenary and must be a male member of that joint Hindu family, then by birth he got the right to property in the coparcenary property, which is otherwise called right by birth, and the very devolution of that property is ruled by the very order of survivorship. And as we have to define that coparcenary property is otherwise the ancestral property, and it is quite different from self-acquired property. And as ancestral property, so every male member of that coparcenary has absolute right of ownership over the joint property or the coparcenary. So the property, if jointly acquired, it will be a part of the coparcenary property. And if any separate property acquired by any member of the coparcenary, then it would form a part of the common stock. So, regarding the very question of the Hindu Succession Amendment Act of 2005, it radically changed this very rule that was common among the Mithakar school, and with the very change in the parent act, that is Hindu Succession Act 1956, which also include the very rule of successions beside the rule of survivorship into the joint Hindu coparcenary right over the ancestral property. And as in the traditional law, the female members are excluded out of the coparcenary right to property, and that was a change brought under the Hindu Succession Amendment Act 2005, and which provided equal right, share and ownership to the female members of the coparcenary and the joint Hindu family. That means the daughters, and whether married or unmarried, now they are being entitled to a equal share in the ancestral property of that joint Hindu family, which is a part of the coparcenary rights. And this very amendment of 2005 brought the most radical change in the Parent Act, Hindu Succession Act 2005. And in our next video, we'll discuss question number 10 exactly to explain the power of coparcenary to alienate the coparcenary interest in Mithakar coparcenary.